very essence of civil liberties certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection. The government of the United States has been emphatically termed a government of laws and not of men. Howdy everybody, and welcome. You are watching The Defenders of Rights. We are bringing you part 3 of episode 4 of Learning the Law. You're definitely going to want to stay tuned because we have plenty of sections and amendments to cover in this episode. It's going to blow your mind. Of course, you know quite a bit of them already, but we're going to dissect them individually and going to explain them with case law, some definitions, so on and so forth. So please stay tuned. Now, we always begin every episode of Learning the Law by thanking the viewers and the subscribers for checking out our channel. Please spread the word, share these videos, do whatever you gotta do to help us, to help yourself, to help each other destroy these corrupt government officials. Tear down the system that they've been using against us for years, for centuries. We definitely want to thank you for all of your support. And if you haven't already yet, please hit the like button. And when you check out our videos, of course you gotta subscribe. Most importantly, we want to thank the Lord Jesus Christ for always being there for us, always helping us get through the tough times, for giving us the strength, the courage, and the wisdom to do what's right and to fight for what's right. We thank Him for all of His blessings. He keeps us going. He keeps us focused. We love Him very much for that. He died on that cross with the rulers looking over Him, thinking they have destroyed this false prophet. And lo and behold, they were wrong. So wrong. There were rulers then, and there's rulers now, and they work in the shadows, conjuring up the forces of evil to destroy us common folk. Well, the defenders of rights are going to stand toe to toe. Bring it on. Let's dive into this, shall we? First section we come across is the Bill of Rights, Amendment 1 of the Constitution for the United States of America. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably to assemble, and to petition the government for a redress of grievances. That's one of the amendments I know your public schools covered, but we're going to elaborate on that with some case law. So the first case we got is United States versus Hilton. This is the United States Court of Appeals, 5th Circuit in 1983. The Court of Appeals declared, as the United States Supreme Court has held, the right to petition for redress of grievances is among the most precious of the liberties safeguarded by the Bill of Rights. Inseparable from the guaranteed rights entrenched in the First Amendment, the right to petition for redress of grievances occupies a preferred place in our system of representative government and enjoys a sanctity and a sanction not permitting dubious intrusions. Indeed, it was not by accident or coincidence that the rights to freedom in speech and press were coupled in a single guarantee with the rights of the people peaceably to assemble and to petition for redress of grievances. Moreover, the Supreme Court has held expressly that the First Amendment right to petition protects the individual's right to file an action with a reasonable basis in a state tribunal. Shortly after the original Constitution was adopted, again undoubtedly in an attempt to secure the blessings of liberty, the Bill of Rights was added to the Constitution, in which the First Amendment, later made applicable to the states by the 14th Amendment, provides that Congress shall make no law abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. We conclude that it would be destructive of rights of association and of petition to hold that groups with common interests may not, without violating the antitrust laws, use the channels and procedures of state and federal agencies and courts to advocate their cases. Having thoroughly reviewed the record in the district court's holding, we have concluded that Hilton's actions represent a legitimate and protected exercise of her right to petition for the redress of grievances. The record clearly reveals that Hilton placed a high value upon her right to personal privacy and genuinely attempted to protect her rights through the orderly pursuit of justice, the filing of citizen complaints with a reasonable basis. Although we do not condone the Hilton's continued opposition to this nation's tax laws, we likewise cannot condone the imposition of criminal sanction for Hilton's exercise of her constitutional right. Amen. Likewise, we consider it irrelevant to the applicability of the right to petition that its exercise might have the effect of causing professional injury to the official about whom complaints are made, or even that the complainer may be aware of or pleased by the prospect of such injury. Whenever substantial charges of any credibility are made, a shadow of doubt at least may fall upon their object. This effect follows too naturally from its cause for its presence to vitiate the propriety of the use of First Amendment rights, if those rights are to retain meaning. The possibility that a citizen who feels himself to have been abused by a particular federal official may take satisfaction when the official gets his perceived due is too human for First Amendment protection to depend on its absence. And that case is particularly talking about our right to petition the government for redress of grievances. Anything done to us, anytime we suffer an injury, we have the right to petition the courts. We have the right to complain about these public officials violating rights, assaulting, threatening, coercing individuals. They need to have their day in court, and we need to have a jury decide on their fate. That is the law. Next is American Federation of State, County, and Municipal Employees versus Woodward. This is the United States Court of Appeals, 8th Circuit in 1969. End quote. The First Amendment protects the right of one citizen to associate with other citizens for any lawful purpose, free from government interference. The guarantee of the right of assembly protects more than the right to attend a meeting. It includes the right to express one's attitudes or philosophies by membership in a group or by affiliation with it or by other lawful means. Union members is protected by the right of association under the 1st and 14th Amendments. End quote. That's a very important court case to me because I am a carpenter. I work for the union. We have a right to association. That's our First Amendment right. Therefore, we are protected by the 1st and 14th Amendment to have a union membership. That just doesn't go for carpenters union or millwrights union or welders union. I go for teachers union, so on and so forth. Next, Article 1, Bill of Rights, Section 9 of the Indiana Republic Constitution of 1816. That the printing presses shall be free to every person who undertakes to examine the proceedings of the legislature or any branch of government, and no law shall ever be made to restrain the right thereof. The free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. Now that section is a reflection of the First Amendment of the Constitution for the United States of America. But we're not going to dive into that one because there's a new one. Article 1, Bill of Rights, Section 9 of the Indiana Republic Constitution of 1851. And it even got the same section in this Constitution. No law shall be passed restraining the free interchange of thought and opinion, or restricting the right to speak, write, or print freely on any subject whatever. But for the abuse of that right, every person shall be responsible. I would have to say I like the 1816 version better, but still covers the same concepts, still gives us the same protection for the same rights. Just like this document, I have the right to speak and print it freely and distribute it freely because it is my thoughts and opinions. It is others' thoughts and opinions. It's declared fact and truth. Same goes for every other single individual's writings, anything that they print, anything they want to speak or think. They have a right to do so, free from any restrictions from the government. Just like this YouTube channel. It is a free interchange of thought and opinion. The right to record. It's the same thing as to write or print. And we get to do it freely, anywhere, except on private property, of course. Next, Article 1, Bill of Rights, Section 10 of the Indiana Republic Constitution of 1816. In prosecutions for the publication of papers investigating the official conduct of officers or men in a public capacity, or when the matter published is proper for the public information, the truth thereof may be given in evidence, and in all indictments for libels, the jury shall have a right to determine the law and the facts, under the direction of the court, as in other cases. Now that one is talking about private citizens informing the public on public official corruption, which is good. That one's a good one. Unfortunately, this has been taken out of the current Constitution, and I do not know why. Part of it has, at least. Next, Article 1, Bill of Rights, Section 10 of the Indiana Republic Constitution of 1851. In all prosecutions for libel, the truth of the matters alleged to be libelous may be given in justification. Now, libel occurs on a daily basis. Libel is when a newspaper will print an article talking about somebody, something that they did, and it's all false. And it affects their character out in the public. And libel covers many other circumstances as well. Next, Article 1, Bill of Rights, Section 19 of the Indiana Republic Constitution of 1816. That the people have a right to assemble together in a peaceable manner, to consult for their common good, to instruct their representatives, and to apply to the legislature for redress of grievances. Don't that sound like an amendment that you've already heard? Oh yeah. Next, Article 1, Bill of Rights, Section 31 of the Indiana Republic Constitution of 1851. No law shall restrain any of the inhabitants of the state from assembling together in a peaceable manner, to consult for their common good, nor from instructing their representatives, nor from applying to the General Assembly for redress of grievances. Bam! There it is, our current one, expressing to the people of our First Amendment right. So in the Indiana Republic, our First Amendment right also is Article 1, Section 31, constitutional right. Next, Bill of Rights, Amendment 2 of the Constitution for the United States of America. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We all know our Second Amendment right. There's a reason why it's number 2. I'll have some case law to go with that, but not in this episode. But how important is our Second Amendment right? We must protect ourselves, our family, our property, and the most sufficient, effective way to do that is arms. Not firearms, because we all know firearms is another terminology, another term of art, word of art, that the government has used and manipulated to deceive the masses. We don't purchase firearms. Those are explosives, by definition. We purchase arms. Not weapons, not firearms, arms. Guns that will protect us, ourselves, our family, our property. Next, Article 1, Bill of Rights, Section 20 of the Indiana Republic Constitution of 1816. That the people have a right to bear arms for the defense of themselves and the state, and that the military shall be kept in strict subordination to the civil power. I'm going to elaborate on these here in just a minute. Let's continue further. Article 7, Militia, Section 1 of the Indiana Republic Constitution of 1816. The militia of the state of Indiana shall consist of all free, able-bodied male persons, Negroes, mulattoes, and Indians excepted, resident in the said state, between the ages of 18 and 45 years, except such persons as now are, or hereafter may be exempted by the laws of the United States, or of this state, and shall be armed, equipped, and trained, as the General Assembly may provide by law. Next, Article 12, Militia, Section 1 of the Indiana Republic Constitution of 1851. A militia shall be provided and shall consist of all persons over the age of 17 years, except those persons who may be exempted by the laws of the United States or of this state. The militia may be divided into active and inactive classes, and consist of such military organizations as may be provided by law. I will ask, does anybody know about their militia or hear about their militia in their State of the Union? Because not once. I keep up with the news too, and there's not once in my life have I heard about our militia here in the Indiana Republic. Maybe we need to start changing that. Maybe we the people need to form our own militia. In fact, I think it's overdue, because we are being overran and taken over by a corrupt system. And it's using its military against us. In fact, it's incorporating military tactics, gear, ammunition, the complete package on our civil power. By that I mean the cops are now militarized. No. No, 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 no! And see, this is where we need our militia. Next, Article 1, Bill of Rights, Section 32 of the Indiana Republic Constitution of 1851. The people shall have a right to bear arms for the defense of themselves and the state. Article 1, Bill of Rights, Section 33 of the Indiana Republic Constitution of 1851. The military shall be kept in strict subordination to the civil power. Okay, now it's time to elaborate on these. Of course, as I just mentioned a little bit ago, our Second Amendment right is also our Article 1, Section 32 constitutional right here in the Indiana Republic, and that's the right to bear arms. And along with that, with Section 33, the very next section, the military shall be kept in strict subordination to the civil power. Not convert the civil power to military ways. No. They're both are meant to be kept separate, under strict regulations. And our militia needs to be established, and that goes for every state of the Union. We the people must make a militia for the protection of ourselves, our family, our property, our country. So yes, I'm highly advising all you folks who are listening to think about that and perhaps make a change in your community by doing just that. Because I know I am, and those who aren't or are afraid are going to be thanking me for doing so. They're going to be supportive of me for doing so, because I'll be there to protect them and their family. That's my duty, is to love thy neighbor, and I shall continue to do so until the day I die. And the Second Amendment right, Article 1, Section 32 right, leads into the next one. The Bill of Rights, Amendment 4 of the Constitution for the United States of America. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. I'm sure I don't have to elaborate on that one, but I'm going to in just a little bit. Next, Article 1, Bill of Rights, Section 8 of the Indiana Republic Constitution of 1816. The rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Sounds pretty much the damn same when we're comparing it to our Fourth Amendment right. But let's go further. Article 1, Bill of Rights, Section 11 of the Indiana Republic Constitution of 1851. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search or seizure shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or thing to be seized. Now we can go ahead and elaborate on it. We all know our Fourth Amendment right, and here in the Indiana Republic, it's our Article 1, Section 11 constitutional right, that we cannot be unreasonably searched or seized. And that can occur anytime, anywhere you come across a law enforcement officer. Even DCS, when they go to your school and want to investigate, they want to interview your children. Bam! Fourth Amendment applies. There are statutory requirements incorporated into each code of each state of the Union to protect this right for a good reason. So always exercise your Fourth Amendment right. Always exercise your Article 1, Section 11 constitutional right, because it covers a lot with your taxes, traveling back and forth to work in your own private automobile, anything that has any information on it, any paperwork, anything in your house, any of your property, anything that's on you, on your persons, anything that's personal effects. It all is protected by those sections, those amendments. Next, Bill of Rights, Amendment 5 of the Constitution for the United States of America. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Woo! There is a lot to cover in that one. So no infamous crime can you be convicted of unless it's by presentment or indictment of a grand jury. That's a grand jury, not a deputy prosecuting attorney or a prosecuting attorney. Grand jury. No person shall be put twice in jeopardy of life and limb for the same offense. So you can't commit the same offense and be tried for it twice. In other lingo, no bueno. and nobody is going to be compelled to be a witness against himself or herself. When a public official stops you and asks you questions, you do not answer. You have a right to remain silent. As Dave Chappelle put it to us, I plead the fifth. F-I-F, fifth. You plead the fifth. And no private property shall be taken for public use without just compensation. That also includes you registering your vehicle, your private automobile. You are now making it into a motor vehicle when you register it with the BMV/DMV. And when you do that, it becomes public property. We're not receiving any just compensation for that. Violation of the law right there. Violation of your Fifth Amendment right. And I say the most important in that amendment is not to be deprived of life, liberty, or property without due process of law. Due process of law is something that we all must receive when we go to court. That is the one that protects us most, is the due process of law. That's what makes all of the constitutions apply. It's because of that due process of law. Because it's the process that we're due when dealing with the law. Next, Article 1, Bill of Rights, Section 7 of the Indiana Republic Constitution of 1816. That no man's particular service shall be demanded or property taken or applied to public use without the consent of his representatives or without a just compensation being made therefor. A derivative of the Fifth Amendment. Next, Article 1, Bill of Rights, Section 14 of the Indiana Republic Constitution of 1851. No person shall be put in jeopardy twice for the same offense. No person in any criminal prosecution shall be compelled to testify against himself. Another derivative of the Fifth Amendment. Next, Article 1, Bill of Rights, Section 21 of the Indiana Republic Constitution of 1851. No person's particular services shall be demanded without just compensation. No person's property shall be taken by law without just compensation, nor, except in case of the state, without such compensation first assessed and tendered. That is another derivative of the Fifth Amendment. Next, Article 1, Bill of Rights, Section 12 of the Indiana Republic Constitution of 1816. That no person arrested or confined in jail shall be treated with unnecessary rigor or be put to answer any criminal charge but by presentment, indictment, or impeachment. Next, Article 1, Bill of Rights, Section 15 of the Indiana Republic Constitution of 1851. No person arrested or confined in jail shall be treated with unnecessary rigor. I'm going to elaborate on that one. Unnecessary rigor means being treated terribly. It means being punished harshly. No person shall have to undergo that. That is a constitutional right. Next, Article 3, Section 2, Clause 3 of the Constitution for the United States of America. The trial of all crimes, except in cases of impeachment, shall be by jury. And such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. So there is a strict mandate to the government. The trials of all crimes, except in cases of impeachment, shall be by jury. Now I'm going to elaborate on this one in another episode, but for God's sakes, people, why do we have judges or magistrates determining our cases? Why do we have them determining the law and the facts? Or the facts and the law? Why? Because we have the right to a jury trial. Why was that incorporated into our Constitution? Because back in the day, and still now, to this very day, having a jury is part of due process of law. It is a fair trial. Whereas having just one, and 95% of them are corrupt, that is an unfair trial. That is bias. That is prejudice. And they act like it and are consistently on the daily. To every single person who walks in that courthouse, a judge or magistrates are strictly biased and prejudiced for a reason. That's more money in their pocket. They're part of the system, the corrupt system that we've had to live in. Next, Bill of Rights, Amendment 6 of the Constitution for the United States of America. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Now I'm going to elaborate on this one with some case law in just a bit. Let's go further. Article 1, Bill of Rights, Section 13 of the Indiana Republic Constitution of 1816. That in all criminal prosecutions, the accused hath a right to be heard by himself and counsel, to demand the nature and cause of the accusation against him, and to have a copy thereof, to meet the witnesses face to face, to have compulsory process for obtaining witnesses in his favor, and in prosecutions by indictment or presentment, a speedy public trial by an impartial jury of the county or district in which the offense shall have been committed, and shall not be compelled to give evidence against himself, nor shall be twice put in jeopardy for the same offense. Boy, that section covers a lot. Too bad it's in the old Constitution here in the Indiana Republic. Or did we incorporate that into the new one? Let's see. Next, Article 1, Bill of Rights, Section 13A of the Indiana Republic Constitution of 1851. In all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed, to be heard by himself and counsel, to demand the nature and cause of the accusation against him, and to have a copy thereof, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. We are definitely going to elaborate on this with some case law, like I said. First court case we come across is Miller v. State. This is the Supreme Court of the Indiana Republic in 1987. In quote, the confrontation right in 17th century English common law is said to have evolved from public backlash to the abuses which occurred during Sir Walter Raleigh's trial for treason in 1603. Raleigh's conviction rested in great part on a written confession given outside his presence by his alleged co-conspirator, who was not present at trial. The Knight of Muddied Cape Frame, who was not permitted counsel, implored the court for confrontation. The proof of the common law is by witness and jury. Let Cobham, his alleged co-conspirator, be here. Let him speak it. Call my accuser before my face, and I have done. To which Judge Warburton responded, I marvel, Sir Walter, that you being of such experience and wit should stand on this point, for so many horse stealers may escape, if they may not be condemned without witnesses. The common law right of confrontation was planted firmly in the American colonies. Confrontation clauses were included in most of the first state constitutions, adopted at the sort of the Revolutionary War. Those constitutions served as models for the United States Constitution and the Bill of Rights. As with the common law confrontation right, the general purpose of these clauses was to prevent the trial of criminal cases upon affidavits. Courts and scholars have generally concluded that the essential purpose of the federal confrontation right is to secure to the defendant the opportunity of cross-examination. The Supreme Court has described the nature of confrontation at trial as a personal examination and cross-examination of the witness, in which the accused has an opportunity not only testing the recollection and sifting the conscience of the witness, but of compelling him to stand face to face with the jury in order that they may look at him and judge by his demeanor upon the stand and the manner in which he gives his testimony whether he is worthy of belief. Most recently, Justice Blackmun reminded us that these means of testing accuracy are so important that the absence of proper confrontation at trial calls into question the ultimate integrity of the fact-finding process. While Wigmore calls the witness's presence before the tribunal a result accidentally associated with the process of confrontation, courts have tended to regard the jury's opportunity to view the demeanor of the witness as a critical component of the confrontation right. The Sixth Amendment right of confrontation is made obligatory on the states by the 14th Amendment. Criminal defendants in this state have an independent right of confrontation arising from Article 1, Section 13 of the Indiana Constitution. It provides, in all criminal prosecutions, the accused shall have the right to meet the witnesses face to face. With few exceptions, Indiana appellate courts have analyzed these confrontation questions with reference to federal case law and treated the state provisions as providing guarantees similar to its federal counterpart. For instance, in Laganore v. State, this court held that the right to confront witnesses guaranteed by both the federal and state constitutions includes the right to full, adequate, and effective cross-examination, and declared this right fundamental and essential to a fair trial. References to federal authority notwithstanding, Indiana courts have clearly determined that cross-examination is the primary interest secured by the confrontation right in Article 1, Section 13 of the Indiana Constitution. The confrontation rights granted by the Indiana Constitution and the Federal Constitution may differ to some degree. The Indiana Clause requires face-to-face confrontation, while the Federal Clause mandates only a general right to be confronted with the witnesses. This court has held that the preliminary hearing testimony of a witness unavailable at trial is admissible under the Indiana Constitution if, at that preliminary hearing, the defendant either cross-examined the witness or had the opportunity to do so. In Gallagher, the Court of Appeals found no error in the defendant's absence from a deposition requested by the defense. The deposition in Gallagher was not taken to preserve testimony for trial. The court went on to say, "We believe, although it is unnecessary for us to decide, that when the state takes a witness's deposition to perpetrate the testimony for use at trial, the defendant and his counsel should be given notice of the deposition and an opportunity to confront and cross-examine the witness. If this procedure is followed, the trend is to allow the deposition to be admitted at trial as substantive evidence if the witness is unavailable. Indeed, we believe that the admission of a deposition at trial which was taken in the absence of the defendant or his counsel could be so fundamentally unfair as to violate the defendant's due process rights." For purposes of this case, this distinction leads us to regard Bowen and Gallagher as standing for the broad proposition that a defendant must have an opportunity for cross-examination before the out-of-court testimony of an absent witness is admissible at trial. In light of Bowen and Gallagher and our recognition that cross-examination is at the core of the Indiana Confrontation Clause, it is clear that use of a statement videotaped under Indiana Code Section 35-37-4-6 must be accompanied by some opportunity for cross-examination if it is to comply with the Indiana Constitution. The goal of the statute is to reduce the child's emotional trauma caused by numerous court appearances, not to guarantee that the child will never have to face the defendant. Even against the pressure of policies favoring specialized treatment of child victims, the Confrontation Clause in Article 1, Section 13 of the Indiana Constitution does not permit wholesale denial of cross-examination. The defendant was never affirmatively given the opportunity to question the victim. There is a preassumption against the waiver of constitutional rights. For a waiver to be effective, there must be an intentional relinquishment or abandonment of a known right or privilege. Such proof of affirmative waiver, even if it were sufficient for reversal, does not exist here. Although a violation of the Confrontation Clause may constitute harmless error, that is not the case here. The videotaped statement of the victim constituted particularly damaging evidence. No other direct evidence linked Annabelle to the molestations, although the medical evidence made clear that the molestations had occurred. The child's testimony on the videotape was straightforward and convincing. It can hardly be claimed that the central evidence against the defendant was harmless. That court case was self-explanatory. Next, Article 1, Bill of Rights, Section 11 of the Indiana Republic Constitution of 1816. That all courts shall be open, and every person for an injury done on him in his lands, goods, persons, or reputation shall have remedy by due course of law, and right and justice administered without denial or delay. We will elaborate on that once I get to the 1851 Constitution. Next, Article 1, Bill of Rights, Section 12 of the Indiana Republic Constitution of 1851. All courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. So what those sections are covering is the due course of law. So the most important things in those sections is the due course of law, which is synonymous with due process of law. They are the same thing, they mean the same thing. That right there is simply just saying every man or woman has the right to go to the courts and seek a remedy for whatever injury they have suffered, whether it's in their person, reputation, or property. And that justice shall be administered freely. You don't have to pay to have the courts service you at all. That is your right. It needs to be done without prejudice, without bias. It needs to be completely fair, without denying your constitutional rights. And it needs to be done within a reasonable amount of time and without delay. Next, Article 5, Judicial Branch, Section 11 of the Indiana Republic Constitution of 1816. The style of all process shall be the state of Indiana. All prosecutions shall be carried on in the name and by the authority of the state of Indiana, and all indictments shall conclude against the peace and dignity of the same. We are definitely going to elaborate on that after the next one. Article 7, Judicial, Section 18 of the Indiana Republic Constitution of 1851. All criminal prosecutions shall be carried on in the name and by the authority of the state, and the style of all process shall be, in quotations, the state of Indiana. Now I can go ahead and elaborate on this. The style being used by the courts currently is, in quotations, state of Indiana, or, in quotations, all caps, state of Indiana, not the style necessitated by the Indiana Republic Constitution of 1851. And by that I mean it's not in quotations, capital T for the, capital S for state, and capital I for Indiana, all of that in quotations, the state of Indiana. That is how the style of process is supposed to be, of all process. Okay? This is because the constitutional private citizens of the Indiana Republic, or American citizens or state nationals, are consenting or contracting with the federal corporate instrumentality of the federal corporate U.S., known as the state of Indiana, all caps, or state of Indiana, or any other grammatical variations thereof, the statutory state, the federal area within the constitutional Indiana Republic. That's what's going on. It's not the actual republic, it's not the actual state of the union that you're dealing with, not the actual Indiana Republic. It is the federal area that you're dealing with. When they use the process, state of Indiana or state of Indiana all caps or any derivatives thereof, you're dealing with a statutory state, not a constitutional state. There are two contexts when you're dealing with the law. There are statutory and then there is constitutional. You must know what you're dealing with. You can go ahead and check. I'm sure there's quite a bit of you that have been summoned into court here in the Indiana Republic. Check it out. It'll say state of Indiana or all caps state of Indiana. There's a reason for that. I just told you. Now, state of Indiana has been put on standby. After watching this episode, the secret's out. Next, Bill of Rights, Amendment 7 of the Constitution for the United States of America. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. That is also another very important amendment. It should be about 95% of the time when you're summoned into court, it should be done in the common law jurisdiction. But it's not. Commerce has taken control of everything, denying our right to trial by jury. Example, you're driving, in quotations, your motor vehicle, in quotations, you get pulled over, get a ticket, you get summoned into court, and now you just found out that your license is suspended. Oh no. Now you're getting charged with a Class A misdemeanor for driving while license suspended, up to a year in jail or a year's probation. That right there is taking out the common law jurisdiction. You're automatically in the Admiralty Maritime jurisdiction, because that's the jurisdiction that commerce falls under. And that's just one simple example. There are thousands more of examples where crimes are being converted into the commerce jurisdiction, aka Admiralty Maritime jurisdiction. Next, Article 1, Bill of Rights, Section 5 of the Indiana Republic Constitution of 1816. That in all civil cases, when the value in controversy shall exceed the sum of $20, and in all criminal cases, except in petite misdemeanors, which shall be punished by fine only, not exceeding $3, in such manner as the legislature may prescribe by law, the right of trial by jury shall remain inviolate. Well said by that section. I'll just remind you that the right of trial by jury shall remain inviolate. You shall always have the right to a trial by jury at all times and in all places. That's what that means. Next, Article 1, Bill of Rights, Section 19 of the Indiana Republic Constitution of 1851. In all criminal cases whatever, the jury shall have the right to determine the law and the facts. Now ain't that the truth? Not the judges, it's the jury. Which correlates to the next one, Article 1, Bill of Rights, Section 20 of the Indiana Republic Constitution of 1851. In all civil cases, the right of trial by jury shall remain inviolate. So as you can see, in all criminal cases and in all civil cases, you got the right of trial by jury, and they shall determine the law and the facts. These are our rights, people. Start exercising them. Next, Bill of Rights, Amendment 8 of the Constitution for the United States of America. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. I'll elaborate on this one in just a bit. Next, Article 1, Bill of Rights, Section 15 of the Indiana Republic Constitution of 1816. Excessive bail shall not be required, excessive fines shall not be imposed, no cruel and unusual punishments inflicted. Same thing as our 8th Amendment right. Next, Article 1, Bill of Rights, Section 16 of the Indiana Republic Constitution of 1851. Excessive bail shall not be required, excessive fines shall not be imposed, cruel and unusual punishments shall not be inflicted. All penalties shall be proportioned to the nature of the offense. So these sections and that amendment are elaborating the fact that we shouldn't be bailed on a huge ass bond. All penalties shall be proportioned to the nature of the offense. So if you committed a misdemeanor, then the fines and penalties will be proportioned to that offense. Whereas if you committed a felony, as in murdering somebody, well, then you're going to obviously see the fines and penalties skyrocket, because that is one of the ultimate sins you do not do. And then cruel and unusual punishments shall not be inflicted. Now that's during the whole trial proceedings and along with you being imprisoned. You shall not be inflicted upon by cruel and unusual punishment. Next, Article 1, Bill of Rights, Section 14 of the Indiana Republic Constitution of 1816. That all persons shall be bailable by sufficient sureties, unless for capital offenses, when the proof is evident, or the presumption great. And the privilege of a writ of habeas corpus shall not be suspended, unless, in case of rebellion or invasion, the public safety may require it. I will cover this one in just a bit. Article 1, Bill of Rights, Section 17 of the Indiana Republic Constitution of 1851. Offenses other than murder or treason shall be bailable by sufficient sureties. Murder or treason shall not be bailable when the proof is evident or the presumption strong. Next, Article 1, Bill of Rights, Section 27 of the Indiana Republic Constitution of 1851. The privilege of the writ of habeas corpus shall not be suspended, except in case of rebellion or invasion, and then only if the public safety demand it. So the writ of habeas corpus is when you're already falsely imprisoned. You're in jail or in prison, and you're in there for a whole bunch of wrong reasons, or just even one wrong reason. You have the right to file and to petition the government with that habeas corpus. That saves your ass. That'll get you out of jail. That's your ticket out of jail and to receive justice properly. And with the corruption going on nowadays, the habeas corpus, I'm sure, is used on the daily for a multitude of reasons. Next, Bill of Rights, Amendment 9 of the Constitution for the United States of America, another very important one. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And I'll be glad to elaborate on this one. So let's define enumerated. According to Black's Law Dictionary, 2nd edition, which was published year 1910, page 430, enumerated is defined as, this term is often used in law as equivalent to mentioned specifically, designated, or expressly named or granted, as in speaking of enumerated governmental powers, items of property, or articles in a tariff schedule. Alright, so let's look at examples of other rights not enumerated, not mentioned in the Constitution. The right of privacy, which is one of the most sacred of all rights. Pursuant to Black's Law Dictionary, 6th edition, page 1195, right of privacy is defined as the right to be let alone, the right of a person to be free from unwarranted publicity, and right to live without unwarranted interference by the public in matters with which the public is not necessarily concerned. Term right of privacy is generic term encompassing various rights recognized to be inherent in concept of ordered liberty, and such right prevents governmental interference in intimate personal relationships or activities, freedoms of individual to make fundamental choices involving himself, his family, and his relationship with others. Tort actions for invasion of privacy fall into 4 general classes. Appropriation, consisting of appropriation for the defendant's benefit or advantage of the plaintiff's name or likeness. Intrusion, consisting of intrusion upon the plaintiff's solitude or seclusion, as by invading his home. Eavesdropping, as well as persistent and unwanted telephone calls. Public disclosure of private facts consisting of a cause of action and publicity of a highly objectionable kind, given to private information about the plaintiff, even though it is true and no action would lie for defamation. False light in the public eye, consisting of publicity which places the plaintiff in a false light in the public eye. Next, we have a court case that further explains the right to privacy. It is Henry v. Cherry Webb. This is the Supreme Court of the Rhode Island Republic in 1909. For the sake of conserving time, I'm not going to read all of this case, but I am going to take a section out of it and read it to you because I feel it is important for you to know. And quote, "It is evident, therefore, that the court considered the right of privacy as a natural right, and that natural rights are something reserved from all governments when society was formed. In other words, that there are rights reserved to the people other and above those guaranteed by the constitutions of the United States and states, and that these rights are enforceable in the court of justice. It is also obvious that, the right being reserved from all government when society was formed, its binding force on the legislature, a branch of the government, is as transcendent as it is on the judiciary, a branch of the same government. In creating a legislative department and conferring upon it the legislative power, the people must be understood to have conferred the full and complete power as it rests in, and may be exercised by, the sovereign power of any country, subject only to the such restrictions as they may have seen fit to impose, and to the limitations which are contained in the Constitution of the United States." So as this court case made evident, the right of privacy is considered a natural right, and it is beyond reach of the government. It is a constitutionally protected and secured right. Although it's not mentioned in the constitutions, it is there. It is in the Ninth Amendment. Another right that's in the Ninth Amendment, not enumerated in the Constitution, is the right of family integrity. According to Black's Law Dictionary, 8th edition, published year 2004, page 4126, the definition of right of family integrity is a fundamental and substantive due process right for a family unit to be free of unjustified state interference. While not specifically mentioned in the U.S. Constitution, this right is said to emanate from it. The contours of the right are nebulous and incompletely defined, but it at least includes the right to bear children, the right to rear them and to guide them according to the parents' beliefs, as well as of the right of children to be raised by their parents, free of unwarranted interference by state officials. So as you can see, pursuant to the Ninth Amendment, we have the right to family integrity. We have the right to raise our family the way we see fit, without unwarranted interference by public officials. And the case that goes into detail about this is Griswold versus Connecticut. This was the United States Supreme Court in 1965. A beautiful court case, which one you need to have and definitely read over. I'm going to highlight some of the important parts in it. And it talks about the right of association, which is our First Amendment right, which is the same as family integrity. We have a right to associate with our family members, with our friends, with our neighbors. And this court case obviously touches base on the Ninth Amendment. End quote. "The Ninth Amendment to the Constitution may be regarded by some as a recent discovery and may be forgotten by others, but since 1791 it has been a basic part of the Constitution which we are sworn to uphold. To hold that a right so basic and fundamental and so deep-rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution is to ignore the Ninth Amendment and to give it no effect whatsoever. Moreover, a judicial construction that this fundamental right is not protected by the Constitution because it is not mentioned in explicit terms by one of the first 8 amendments or elsewhere in the Constitution would violate the Ninth Amendment, which specifically states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This justice goes further on to say, end quote, "I do not mean to imply that the Ninth Amendment is applied against the states by the 14th, nor do I mean to state that the Ninth Amendment constitutes an independent source of rights protected from infringement by either the states or the federal government. Rather, the Ninth Amendment shows a belief of the Constitution's authors that fundamental rights exist that are not expressly enumerated in the first 8 amendments, and an intent that the list of rights included there not be deemed exhaustive. As any student of this court's opinions knows, this court has held, often unanimously, that the 5th and 14th Amendments protect certain fundamental personal liberties from abridgment by the federal government or the states. The Ninth Amendment simply shows the intent of the Constitution's authors that other fundamental personal rights should not be denied such protection or disparaged in any other way simply because they are not specifically listed in the first 8 constitutional amendments. I do not see how this broadens the authority of the court. Rather, it serves to support what this court has been doing in protecting fundamental rights. Nor am I turning somersaults with history and arguing that the Ninth Amendment is relevant in a case dealing with the state's infringement of a fundamental right. While the Ninth Amendment, and indeed the entire Bill of Rights, originally concerned restrictions upon federal power, the subsequently enacted 14th Amendment prohibits the states as well from abridging fundamental personal liberties. And the Ninth Amendment, in indicating that not all such liberties are specifically mentioned in the first 8 amendments, is surely relevant in showing the existence of other fundamental personal rights now protected from state as well as federal infringement. In sum, the Ninth Amendment simply lends strong support to the view that the liberty protected by the 5th and 14th Amendments from infringement by the federal government or the states is not restricted to rights specifically mentioned in the first 8 amendments. That was beautifully said. Let me end off with one more quote from this justice. And quote, "In determining which rights are fundamental, judges are not left at large to decide cases in light of their personal and private notions. Rather, they must look to the traditions and collective conscience of our people to determine whether a principle is so rooted there as to be ranked as fundamental. The inquiry is whether a right involved is of such a character that it cannot be denied without violating those fundamental principles of liberty and justice which lie at the base of all of our civil and political institutions." Liberty also gains content from the emanations of specific constitutional guarantees and from experience with the requirements of a free society. I agree fully with the court that, applying these tests, the right of privacy is a fundamental personal right emanating from the totality of the constitutional scheme under which we live. So that court case even goes on further to assist further justices and judges on how to determine if a right is so fundamental that it needs protection, and it has protection by the Ninth Amendment. And there you have it. Next, we have Article 1, Bill of Rights, Section 24 of the Indiana Republic Constitution of 1816. To guard against any encroachments on the rights herein retained, we declare that everything in this article is accepted out of the general powers of government and shall forever remain inviolable. And that's obviously good to have in the Constitution. That's just saying that the Constitution stands, the general powers of government are to protect any encroachments on the rights that are mentioned in the Constitution. Next, Bill of Rights, Amendment 10 of the Constitution for the United States of America. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Next, Bill of Rights, the original 13th Amendment of the Constitution for the United States of America. Yes, the original, the very first 13th Amendment. Within our history, there has been 3 13th Amendments. The very first one is this: listen, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without the consent of Congress accept and retain any present, pension, office, or emolument of any kind whatever, from any emperor, king, prince, or foreign power, such persons shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them. So what does that mean? Well, that means simply this. This amendment was created for the lawyers, for the attorneys, specifically. And now the public officials. All of them, because all of them hold allegiance to Great Britain, to the United Nations. And you can go check it out in the United States Code. Anybody who has an allegiance with a foreign power, an emperor, king, prince, nation, however you want to call it, they're committing treason. They're obtaining a title of nobility or honor that they should not hold because they are now putting that emperor, country, foreign power, nation first before the people here in our nation, the United States of America. And lawyers and attorneys definitely have an allegiance to the bar, and the bar all derives from the United Nations, from the great kingdom of Britain. That's where their allegiance falls under. That's why this was created, this amendment right here. You definitely want to research this yourself. There's more research to be done, but it is a proven fact, what I'm telling you right now, the original 13th Amendment. There are facts upon facts to prove its existence. Why was it erased from our history books? I do not know, but I can begin to guess why, and that is because lawyers and attorneys would no longer be. And of course, they're the richest of us all. They're the most corrupt of us all. I do not know why there's so many people who depend on their lawyers, attorneys, to be able to provide them the law or file lawsuits or defend them, represent them in court. Because they're corrupt. They're the most corrupt. They're the ones making the laws and turning everything into what it is now today. That's why I took it upon myself to learn the law myself. That way I can defend myself. And I can assist others. Next, Bill of Rights, Amendment 13, Section 1 of the Constitution for the United States of America. This is our current 13th Amendment. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. So a lot of people are put in involuntary servitude. And one of those instances is when someone is convicted, falsely convicted shall I say, because they were denied due process of law, or they were denied any constitutional rights within a courtroom. That means they weren't duly convicted. They did not receive due process of law. Therefore, they're still innocent, but yet somehow they're locked up behind bars, in prison or in jail, or somewhere staying away from any public officials who are hunting them down. That's involuntary servitude as well. That is considered slavery. Next, Article 11, General Provisions, Section 7 of the Indiana Republic Constitution of 1816. There shall be neither slavery nor involuntary servitude in this state, otherwise than for the punishment of crimes, whereof the party shall have been duly convicted. Nor shall any indenture of any negro or mulatto hereafter made, and executed out of the bonds of this state be of any validity within the state. So there you have the Constitution of 1816 incorporating the 13th Amendment. Well, is also incorporated into the 1851 Constitution. Article 1, Bill of Rights, Section 37 of the Indiana Republic Constitution of 1851. There shall be neither slavery nor involuntary servitude within this state, otherwise than for the punishment of crimes, whereof the party shall have been duly convicted. And of course, I'm going to elaborate a little bit more with this with a court case. And the court case that dives into this is United States versus Komsomolsky. This is the United States Supreme Court in 1988. Just a recent one. And it talks about the slavery and involuntary servitude and what it means and how Congress has made enactments to protect we the people from slavery and involuntary servitude. And so this court goes on to explain in detail, end quote, absent change by Congress, we hold that for purposes of criminal prosecution under Section 241 or Section 1584, the term involuntary servitude necessarily means a condition of servitude in which the victim is forced to work for the defendant by the use or threat of physical restraint or physical injury, or by the use or threat of coercion through law or the legal process. This definition encompasses those cases in which the defendant holds the victim in servitude by placing the victim in fear of such physical restraint or injury or legal coercion. So when anybody in the government, mainly prosecutors or judges, if they use force or threat of force or coercion or physical restraint or physical injury and coerce somebody through the law or the legal process, it's involuntary servitude. Next, we have the Bill of Rights, Amendment 14, Section 1 of the Constitution for the United States of America. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The 14th Amendment is a very important amendment. Glad it was added. It serves its purpose very well, and it holds the states of the Union bound to the Constitution as well. The discrepancies in the Constitution were that it was just directed to the federal government, whereas the 14th Amendment was created and now it's directed to the federal government as well as the states of the Union. And as you can see, are citizens of the United States and of the state wherein they reside. So, you're a citizen of the United States of America as well as a state citizen. We talked about state nationals and state citizens, which are pretty much the same, but you have dual citizenship. And it's very important that you understand your citizenship because it puts you in a locale where you're either protected by the constitutions or you're not. And we'll dive into that into another section, another episode, another video. But I don't have to elaborate on the 14th Amendment because it's been covered through many different articles, many different case law, many different studied books, all that. Next, Bill of Rights, Amendment 16 of the Constitution for the United States of America. The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Now, I'm going to elaborate on that after I go over our next article. Article 10, Finance, Section 8 of the Indiana Republic Constitution of 1851. The General Assembly may levy and collect a tax upon income from whatever source derived, at such rates, in such manner, and with such exemptions as may be prescribed by law. Now, I'll gladly love to elaborate on that amendment and that section in the Indiana Republic Constitution of 1851. No law compels a working eligible man or woman to submit a W-4 or W-9 form, or the equivalent, nor disclose a Social Security number as a condition of being hired or keeping one's job, other than the individuals who are employed with the government, who are the taxpayers, or are public officials, who are also the taxpayers. The people put forth labor in their occupations in an exchange or fair trade for money or other forms of property. The wages or earnings received by the constitutional private citizens of the Indiana Republic, or American citizens or state nationals, are not profited or gained, but are in fact a fair and consensual exchange or a fair and consensual trade for their labor, and the people receive money or other property for their labor, which then becomes their private property. The term income is defined nowhere in Title 26, which is the Internal Revenue Code of the United States Code, which is the prima facie law that relates to the income tax. The term income has repeatedly been held by the courts to indicate gain on capital, and not receipts, wages, compensation, or a fee received in exchange for selling an item of property, which would be labor. Since a tax on property would be a direct, not an apportioned tax that the Constitution for the United States of America does not allow, even selling a house for more than what was paid for it would be a direct tax on property. As seen below, the U.S. Supreme Court has ruled, not just once, but repeatedly, that the federal government cannot levy a tax on private property, and ultimately cannot levy a tax on the labor of the constitutional private citizens of the Indiana Republic, American citizens, or state nationals. All I said right there was so true. I'm about to elaborate more on this. Now remind you, the 16th Amendment says income, and that's what we're proving here. That income isn't labor, isn't considered labor. It's considered gain on capital. It's considered profit. According to Black's Law Dictionary, 6th edition, published year 1990, page 874, labor is defined as work, toil, service, mental or physical exertion. Term in its ordinary use is synonymous with employment, job, or position. Term normally refers to work for wages as opposed to work for profits. There you have it. Labor refers to wages, whereas it does not refer to profits. So the message I'm trying to convey is that income are not the wages that you make from trading your labor for money or for other forms of property. Income is made after you have made your private property, the exchange of money. See, your labor is considered your private property, of course. And then when you exchange that, and when you put forth your labor to whom you work for, then you acquire money or other forms of property in payment for your labor. Anything you make after that is income. That is profits. That is gains. And income is only asserted to those who hold a public office, who work for the government, who are employees of the federal government, as well as the state officials. And there's plenty of case law explaining this. Prudential Insurance Company of America versus Cheek, that was the United States Supreme Court in 1922. Eisner versus Macomber, that was also the U.S. Supreme Court in 1920. The opinion of the justices to the House of Representatives, that was the Supreme Judicial Court of Massachusetts in 1930. Connor versus United States, that was the U.S. District Court, Southern District of Texas, Houston Division in 1969. There is Central Illinois Public Service Company versus United States. That was the United States Supreme Court in 1978. There's Redfield et al. Versus Fisher et al. That's the Supreme Court of the Oregon Republic in 1931. Oliver versus Halstead. That's the Supreme Court of the Virginia Republic in 1955. Helvering, Commissioner of Internal Revenue versus Edison Brothers Store Incorporation. That was the United States Court of Appeals, 8th Circuit in 1943. I mean, the list goes on. I got plenty of case law to read. And we're going to brush up on this topic in another episode when we have more time. Alright, ladies and gentlemen, that does it for now. We are ending part 3 of episode 4. I want to thank you for tuning in, and we got plenty more coming to you. Just remember, you can always count on us, the Defenders of Rights, to teach you how to defend your rights.